Hi there, my name is Brittany Thomas and I'm a solicitor in the family law team at BTO Solicitors based in the Edinburgh office. You may have seen some videos that my colleagues have done over the past couple of weeks regarding different family law issues, and today I'm going to do one myself regarding the relocation of children. Moving to another country is challenging even at the best of times, but it's made even more difficult if you have got children and you are in the process of separating from your partner. With COVID restrictions lifting and flights now taking off, it may be that you are faced with such relocation, be that from your own choice or from that of your partner. Relocations may be triggered due to the breakdown of a relationship, or can in fact take place sometimes further down the line after a breakdown has happened. They are most common when a parent who has got residence of the children, and for the sake of this video we'll call them the resident parent, when the resident parent wishes to relocate with the children to another country and the non-resident parent is going to be remaining in Scotland. There can be a number of reasons why a resident parent wishes to move to another country with their children. It may be firstly that they wish to move back to the country that they lived in prior to moving to Scotland, and it may be that in fact they want to move back to the country that they are originally from in order that they are surrounded by family and friends following the breakdown of the relationship, or it may be that they wish to move to a new country entirely because they have been offered a job there. So the resident parent wishes to move to another country with the children. What's next? The first important point to note is that as long as both parents have got full parental rights and responsibilities regarding the children, then it would be unlawful for one parent to remove the child from the UK without the consent of the other. This applies even if it is just for a week's holiday to Spain or if it's to relocate to Australia. In either situation, the consent of the other parent is required. It may be that the resident and non-resident parent are able to reach agreement regarding the relocation of their children. If this is the case, then that's great news. However, anything that is agreed should be put down in writing. It should be recorded and put down in a legally binding contract known as a minute of agreement. The minute of agreement could set out all of the arrangements regarding the relocation of the children. It could deal with when the contact is to take place between the non-resident parent and the children, for how long for, and for example who is going to pay for flights back and forward between the two countries. It may also deal with the contact during the periods of non-residential contact, i.e. when the children are in the new country. Regardless of what the minute of agreement includes, you should make sure that you obtain specialist legal advice from a family solicitor before you enter into one. This is in order that you can be fully aware of all of the risks of entering into it. The removal of children from the country should always be agreed before it takes place. However, if you are concerned that it's going to take place and you do not consent to doing this, then you should get in touch with a solicitor immediately. This is in order that they can advise you as to the protective steps you can take in order to ensure that this does not happen. For example, you could be asking the court for interdicts in order to prohibit the removal of the children from the country to another. So, there's disagreement as to whether or not the relocation should happen between the resident and the non-resident parent. Can this mean that the relocation can still happen? Ultimately, if one is able to go to a court and obtain a specific issue order allowing the removal of the children to another country, then yes, they will be able to move. So, you're unable to reach agreement and you end up in court looking for a specific issue order in order for the relocation to take place. What are the court going to be looking at in determining whether such a relocation should happen? Ultimately, it will be the welfare of the child that is at the forefront of the court's mind, and whether or not it is in the best interest of the children that the move take place, which is of paramount consideration to the court. The court will take into account a variety of factors in determining whether or not such a relocation should occur. So, after the best interests of the children, there are a number of factors that the court will take into account when determining whether or not the relocation of the children can take place or not. One such factor, and probably the most important factor, is the continued relationship of the non-resident parent with the children. It's highly unlikely that the court will allow for relocation to occur if it will mean that the relationship between the non-resident parent and the children will fail. Other such factors that the court will take into account when determining whether or not the relocation should occur are things such as the resident parent's employment. So have they got a job lined up? Is it a good job? How is it going to pay? Will this result in a higher standard of living for the children in the new country? Also, what is going to happen with the children's education? Is the children's education going to be interrupted by them moving to this new country? Are the schools in the area better? All of these are factors that will be taken into account when the court determines such a decision. Other such factors that the court is going to take into account when determining whether or not the relocation should happen are things such as childcare. So, on the basis that the resident parent is moving to another country and the non-resident parent isn't going to be there in order to assist with the care on a day-to-day basis, childcare will likely need to be in place. It's therefore important to show the court that such childcare can and is available to be obtained. Additionally, another factor will be family relationships. So it is not just the relationship between the child and the non-resident parent that will be taken into account, but whether or not relationships between the children and other family members in Scotland will be disrupted, and again whether or not they will be able to continue. Particularly important in this area will be the relationship between the children and any grandparents that they may be moving away from, or indeed moving to be closer to in another country. In making such a decision, it should be noted that the views of children are deemed to be highly relevant in cases such as these. There is the presumption that children over the age of 12 have got sufficient age and maturity in order to express a view in cases such as these. Therefore, the courts are likely to take them into account. However, it should be noted that there is change coming due to the Children's Scotland Bill, which would get rid of this presumption and mean that children even under the age of 12 would be able to express a view and would have this taken into account. As will be clear from today's blog, relocation actions are incredibly complex and depend entirely on the factual matrix of the case. Indeed, it may be that factors which I have discussed today do not require to be illustrated to the court, and on the other hand, it may be that additional factors need to be illustrated to the court in order to allow for the relocation to take place. In either event, relocation is a huge change for all of those involved, and it is therefore imperative that you obtain specialist legal advice from a family law solicitor as soon as possible. The team at BTO would be happy to assist, and our contact details are below in order for you to contact us. We are experienced in assisting individuals with cases such as these and would be happy to discuss with you the options moving forward.